Hello, everybody on Facebook and on YouTube. Nice to see you. I hope you'll join me for this great information focusing on medical malpractice cases and what happens when your case goes all the way to verdict and you ask a question. If your doctor did in fact screw up, but his screw up did not cause you harm, can you still get money? Can you still get compensation for your injuries, for your damages? You want to learn the answer? Come join me for a moment as I share with you exactly the answer to this question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no. If it turns out that your doctor did in fact screw up, if he departed from good and accepted medical practice, but the jury finds that his improper medical care was not a cause of your injury, guess what? Your case is over and you get nothing. You get bupkis. That's another word for saying you get absolutely nothing. Now, let's go through the scenario so you have a clear understanding of exactly what I'm talking about. You decided to bring a lawsuit against your doctor claiming that, number one, he was careless. He violated the basic standards of medical care. And number two, that his carelessness was a cause of your injury. And, of course, that your injury is significant and or permanent. So now you go to an attorney gets your medical records. He has a medical expert review all of your records, who does, in fact, confirm that you have a valid basis for a case. So you're thinking, terrific, you have a good case, you know exactly what's going on, you know that at some point you're going to go ahead and ultimately be successful. That's your thinking. Okay, that's a great way to think, but now, here's the reality. When you bring your lawsuit, the doctor's going to turn around and say, hey, why did you sue me? I did nothing wrong. Then he's going to say, hey, if I did something wrong, so did you, Mr. Patient. And then he's going to say, you know what, if I did something wrong, whatever I did didn't cause or contribute to your injuries. And then he'll make it even worse for you and say, you know what, if I did something wrong, whatever I did, your injuries really are not as bad as you claim them to be. So they say, listen, we're never going to settle this case. We're never going to negotiate. We will see you at trial. Okay, that means 2 or 3 years down the road, you ultimately get to trial, because that's how long the litigation phase actually takes. So now you finally get to trial. Your case goes on for 2 entire weeks. Your attorney puts on testimony. He puts on all the evidence needed. He shows the jury all the exhibits necessary. He has all of his medical experts testify that, yes, the doctor was careless, and yes, his carelessness caused you harm and injury. And yes, of course, your injuries are significant. Okay, so what's the problem? So now the jury has to answer a series of questions. In other words, their verdict is not based upon just saying, yes, you win, or no, you don't. That's not how it works. So how does it work? Well, at the very end of the case, after the attorneys have made their closing arguments, the judge explains to the jury exactly what the law is in your particular case. And then he said, ladies and gentlemen of the jury, you are going to have to answer the following questions. The answers to those questions form the basis for your verdict. So typically, the very first question in a medical malpractice case involves what we call liability, trying to determine who, if anyone, is legally responsible for what happened here. So typically the question is, was the doctor negligent? In other words, was he careless? Was he professionally careless? Did he depart or deviate or violate the basic standards of medical care? Yes or no? That's the most important question. Actually, that's the very first question. If it turns out that the jury finds that no, the doctor was not careless, he was not negligent, guess what? Your case is over and you get bupkis. You get nothing. What happens, though, if the jury decides, yes, you are more likely right than wrong, that what you are claiming is true, and they believe that you are entitled to a verdict in your favor, and yes, your doctor was in fact careless. Okay, now they go to question number 2, right? Question number 2. And that focuses on what we call proximate cause or causation. Proximate cause really is the link between the carelessness and the wrong. It's the link between the wrongdoing or the carelessness and your injury. There has to be that link, right? So we look to see whether or not there was wrongdoing. We look to see whether or not the wrongdoing was a cause. It doesn't have to be the cause. It only has to be a cause. And then we look to see the extent of your injuries. So the jury is now at question number 2. They're evaluating whether or not the doctor's carelessness, his wrongdoing, was in fact a cause of your injury. And you know what? If in fact the jury decides, you know what? we don't believe that the doctor's carelessness caused or contributed to your injuries, well then, your case is over. And you know what you get? You get bupkis. You get absolutely nothing. And you go home without a dime. And all those years that you spent in litigation and all the time and effort and energy that your attorney spent prosecuting your case. Hey, Steve, nice to see you. Thank you for joining me. Back to Mr. Paulsgraf. Mrs. Paulsgraf. Yes, that's true. Almost true. Yes, we're talking about causation. Then, if there's no causation, if there's no link between the wrongdoing and the injury, then there's a gap. There's a clear gap. And so, the jury will never be permitted to get to the next question, which focuses on damages, how much money you are to receive as a result of that carelessness. So, let's go back to the question I asked at the very beginning. If your doctor screwed up, if he was careless or negligent, but his carelessness was not the reason why you suffered all those injuries, can you still get money? The answer in New York is no, you can't. We must be able to show all three of those things in sequence in order for the jury to get to the ultimate questions of, hey, how much money are they going to give you to compensate you for all of the harms and losses and damages that you incurred? So why do I share this great information with you? I share it with you just to give you an inside look at what really goes on in these medical malpractice cases here in New York. You know, a lot of people don't talk about it, and I think it's so important as you're contemplating bringing a lawsuit for your own matter to understand these concepts, to understand what goes on behind the scenes so that you can become an educated consumer about what you need to do next. And as always, if you have questions about your matter, and your matter did in fact happen here in New York, but you have not yet started a lawsuit, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski. Have a wonderful day. Bye-bye, everybody.